That ground is captured in paragraph 8A of the affidavit. And Your Honor, taking you back to that video that is circulating on social media, which have asked the court to invoke Section 60 of the Evidence Act due to its notoriety, you will see that members of the public were in pursuit of the accused respondent. Not the complainant, but ordinary Kenyans, Your Honor. And we submit, Your Honor, that is a compelling reason showing that there is hostility towards the accused person from the public, which puts his life in danger. Thus, Your Honor, you are saying that the court should deny him bond to safeguard from any person who may feel so aggrieved by the acts of that day. Number 8C, B and C of the affidavit returned by PC Jos Patrotich. Moving on to the next ground in which the state is bond is that there is a likelihood that he will interfere with witnesses, Your Honor. Your Honor, will still be asking the court to act. Judicial notice a social media posting which is doing rounds indicating that the complainant herein has been approached to drop this charge. Your Honor, person is in custody, but efforts are being made to interfere with witnesses. Your Honor, I'm referring to the social media post by one Mike Sonko, in which...
Your Honor, I think counsel, as much as I may not wish to object, cannot submit from the bar in such kind of weighty issues that affect the right of an individual. He needs to refer to us to the affidavit where that has been deponed. Where exactly is that affirmation in the affidavit that is defined?
Paragraph 8B.
Yeah, in respect to whatever you're referring to. Read for us to see.
You cannot read.
You cannot refer to matters of material.
Your Honor, can you protect me from...
You're not under any attack.
I'm under attack from three counsels, Your Honor.
Your Honor, we are protecting the integrity of the process and the integrity of this court so that he does not make submissions from social media when you are appearing here from a court of law and is holding an affidavit. We are saving judicial time.
When I think this affidavit,
you're not the DPP. The DPP is to respond.
I almost was. So, dated 5th June 2024. What my good brother is talking to is what has been posted a few minutes ago. It can't be in the affidavit.
I think let's not forget.
Let him proceed.
According to Mr. Njoroge, his invocation is on the judicial notice.
The judicial notice.
So you can,
and it's a matter of public notoriety.
Judicial notice must be a matter of notoriety.
Yes.
That is not notorious to us. We are not in custody of that information. It's not notorious to us.
It is notorious to everyone else apart from you in this court.
All right.
We'll get your chance.
All right.
Your Honor, having regards to those overtures which have been made to interfere with witnesses, we will be treating to be guided by where it is the point that the feels victimized on social media and has requested before the accused person is released. That, Your Honor, will be a change of circumstance where the accused person can approach this court after the complainant has testified to seek for bail and bond. Your Honor, you will also note that we did serve the affidavit. We have not received a formal response to that affidavit. We have also not received a formal notice to cross-examine the deponent, and we will thus be seeking the court to be guided by the averments in that affidavit.
Mine is just a few things. I wish to invite the court to look at paragraph 8, sub-paragraph A. While we are telling the court that the accused person is a flight risk, we hope the court has had the benefit of seeing the video that has been circulating concerning the offense. And the accused person committed the offense around the morning hours. He was not arrested until the hours of night, for the very reason that he went into hiding. The police officers were scouting for him until they got to wind that during the night he had made his way to his mother's house. This is a demonstration of the capability of the accused person. Well, I would wish to speak for the victim. Mr. Mari is here. And to ask the court, yesterday when we were in court, members of the, I don't want to say the members of the family, but they were coming for the accused person. They took videos which ended up on sites like Tuko. And these efforts are just re-victimizing the complainant. We wonder what will happen if he is let out at this point. A mockery is being made of this case. Actually, this case is such a serious offense. In other jurisdictions, it attracts even a penalty of death.
I agree.
Yes.
Which jurisdiction?
In the states, I don't know which.
Almost all.
Almost all states in the U.S.
But you appreciate being Kenya.
Yes, I do appreciate. But that is why we borrow jurisprudence from others. And a mockery of what happened to the complainant is what is being propagated. And lastly, on the seriousness of the offense. the fact that a 57-year-old policeman who has given service to the Republic of Kenya for over 4 decades was assaulted while in uniform, dragged down, and this pained the members of the public who were there, but they chased after the accused person. This offense is serious. It sends a message to the entire country. How do we treat our officers? How do we treat any member, any public servant? And it is my position that we have laid compelling grounds before you to deny the accused person, especially for the court to have the requests of the complainant at heart, who is the victim, to first testify before any consideration of the application for bond can be considered by the court. The same is in the interest of justice to be all.
We're in the same team on behalf of the victim.
Yes, Your Honor, perhaps before Mr. Omari addresses you, and now that he has confirmed that he's on the same team, you need to give the scope and direction to the scope of his participation pursuant to Section 9, subsection 2A of the Victims Protection. Your Honor, in our humble view, Mr. Omari, at this particular stage, has now outlaid before you with respect to the matters before you. Your Honor, this was held in the case of Waswa versus the DPP in petition number 33 of 2019, the Supreme Court decision, at paragraph 7. Having confirmed that he is with the DPP, he cannot be a secondary prosecutor. His role must be very well defined. And he can only address the question of how will the granting of bail affect victims, if at all there was a victim. Because that now is an allegation that a victim exists.
So I think the jurisprudence on the victim, the role of the victim or the place of the victim in the trial process.
That's correct.
It's not in doubt, yeah?
That's
and
correct.
I think that citation, frankly, I think it's a guiding light on the issue of the victim. But obviously, I think the ratio in that matter is that the scope of the council watching brief of the victim is quite limited.
Yes, sir.
Because they cannot take the role of the DPP, as much as he was just about to be a DPP here. The role of the DPP in that matter, yeah?
Yes, yes.
So I think, Mr. Omari, I think you're very limited, because I believe the other council actually argued very
Well, I know exactly.
And Your Honor, before he submits, he can only submit on paragraph 8, clause E of the
That's
affidavit.
about what he has to say. Yeah, and
Because
then
that is what touches on the victim in this particular affidavit.
Yeah, I do confirm that that position of the DPP is not available for the next 7 years. So let him not worry. I'll address my point based on the complainant and the victim. I want to define who I'm addressing on behalf. The assaulted police officer is the complainant in this matter. His voice before the decision on bail the family of the victim voice officers in this country. That is the family of the complice needs to be heard. Let me start with the complainant, Your Honor. The charge sheet in count 2 reads that on the 2nd day of June 2024, Committee Road in Kasarani sub-county within Nairobi County unlawfully did grievous harm to one Jacob Ogendo. The complainant was grievously harmed. The import of that, in the event he dies, within 1 year and 1 day, the accused shall stand charged with the offense of murder. That is the first angle. Number 2, the effect of those injuries need to be ascertained medically to bring into perspective the seriousness of the offense. Third, Your Honor, the victim is a 57-year-old police officer with children, with a wife, with the mothers-in-law and the fathers-in-law, with the uncles, who are looking at him, one as a failure, 2, a 57-year-old brought down by a 19-year-old. That effect on his self-esteem is devastating. He will definitely need a lot of counseling. That is trauma that cannot be taken lightly.